Hello, everybody, and thank you for joining us this evening. For those of you who don't know me, I'm Jim Anaya, the Dean of the University of Colorado Law School. It's my pleasure to welcome you to the 46th Annual Austin W. Scott Jr. Lecture. Before I go any further, I want to begin by acknowledging that wherever we are in Colorado and elsewhere in North America, we are meeting on the lands of Indigenous peoples. The traditional owners of the land where our campus is located in Boulder, are the Cheyenne, Arapaho, and Ute nations. And I'd like to pay particular respects to the elders, past, present, and emerging, who lead these peoples. This lecture series is named for Austin Scott, a member of the law school faculty for 20 years. He was a beloved teacher, as well as a prolific writer. His scholarly work was in the fields of criminal law and procedure. In 1973, former Colorado Law Dean Don W. Sears established the lecture series in his memory. Each year, the Dean of the Law School selects a member of the faculty engaged in a significant scholarly project to lecture on the research. To be chosen is indeed a recognition with remarkable distinction. It's with great enthusiasm that I welcome Professor Suzette Malveaux to deliver this year's lecture. Suzette Malveaux is Provost Professor of Civil Rights Law and Director of the Byron R. White Center for the Study of American Constitutional Law. She's a nationally recognized expert on civil rights law and class action litigation. Her legal career is dedicated to the pursuit of social justice and making the civil litigation system more equitable. Professor Malveaux has been teaching and writing in the areas of civil procedure and civil rights for 16 years. Prior to joining the Academy, she litigated several major civil rights class action cases, and she did that over 8 years. In this evening's lecture, is it time for a new Civil Rights Act addressing modern obstructionist procedure? Professor Malveaux takes on timely and important issues about access to justice and the adequacy of our legal system to address festering inequities in society. After she speaks, Professor Malveaux will take questions. If you'd like to ask a question or make a brief comment, please use the Q&A function at the bottom of your screen. It's now my pleasure to turn the program over to Professor Suzette Malveaux.
Great, thank you so much, Dean Anaya, for inviting me to give the Scott Lecture this year. Thank you to those who've been working hard to make this happen. Let me quickly recognize them. Melissa Shenter, Yesenia Delgado, John Sabre, Teresa Coberly, Julia Roth, and Angela Betcher. I'm honored to have been chosen to share my scholarship, and I look forward to your thoughts. Let me check first. Can you see my PowerPoint? Good.
Yes, we can see it.
Great. All right. We're gathering at a time of great challenge and profound import in American history. This is a time that calls for serious reflection, rigorous analysis, and ultimately bold action. We're living in what feels like extraordinary times. The country has been destabilized by a number of threats to our democratic norms and institutions, most recently and importantly, the franchise. The country is in the midst of a global pandemic that has pushed people to their limits and highlighted an uncomfortable truth: the ongoing health disparities, making African Americans 3 times more likely to die from COVID-19 than their white counterparts. The country has an extreme wealth gap that has only grown. The richest 1% of Americans have more wealth than the bottom 90%. The average white family has 10 times more net wealth than the average Black family. The country is in the midst of a racial reckoning. There's been justifiable outrage and activism over police brutality across the country. So these feel like extraordinary times. But in many ways, these issues actually are very familiar. Today, the strange fruit that hung from trees in the 1930s lies on the ground in Ferguson for over 4 hours before being picked up. Today, the poll taxes and literacy exams that disenfranchised emancipated slaves post-Reconstruction are the voter ID laws in opposition to mail-in ballots. Today, the slave labor that defined our economy doesn't look very different than the population that feeds our current prison industrial complex. And today, the hooded Ku Klux Klan members whose terror was fed at secret night rallies have been replaced with proud hate groups whose tentacles reach the vulnerable worldwide on the internet and social media. So the United States is in the midst of the largest civil rights movement since that of the 1960s, and calls for justice for Black and Brown people and other marginalized communities grows stronger than ever. Many of us are aware of the violence that has been done to those communities and the significant legislative gains of the 1960s that have resulted. But what has received scant attention is the violence done to those legislative gains by the Supreme Court's increasing obstructionist procedural jurisprudence. So when we think of civil rights, we often think of voting, education, housing, employment. We don't think of procedure as a civil rights issue. But that's the problem. Over the last half century, the Supreme Court has been slowly chipping away at the process by which everyday people have access to the civil court system to resolve their grievances and seek remedies. Meaningful access to the civil justice system is a right that we each have by virtue of the Constitution. It's what we often call this proverbial day in court, right? Yet that access has become increasingly politicized, compromised, and commodified. The court has, in small but powerful ways, systemically eroded Americans' capacity to protect and enforce their substantive rights. And this regressive trend has become even more acute the last quarter century. Now, as a result, various substantive rights are endangered, things like consumer, environmental, constitutional, and civil rights. Now, my work focuses on one subset of rights that are in jeopardy, and those are civil rights. And this focus is warranted not only because of their fundamental place in American history, but because of their precarious future. Over the course of several decades, the pendulum has swung from judicial support for robust private enforcement of federal civil rights to tolerance, if not outright hostility towards those claims. This movement is what Professor Ben Spencer calls going from a liberal ethos to a restrictive one. And much of the things that I draw from have been documented by Professor Steve Burbank and Sean Farran, who I'm grateful for. So what the court has not taken away through substantive rulings, it has done so through procedural rulings, purportedly neutral. The court has made it more difficult to get your foot in the courthouse door through cramped interpretations of statutes of limitations and rigorous pleading standards. The court has made it more difficult to band together and challenge systemic discrimination through class actions. And the court has made it more difficult to even participate in the civil litigation system altogether, as pre-dispute mandatory arbitration agreements force people to waive court access if they want a job, a mortgage, a credit card, cell phone, you name it. So while any one of these developments alone would present a formidable obstacle to those who are challenging discrimination, the confluence of them over the last quarter century illustrates a significant shift away from court access and robust law enforcement. It's the cumulative effect of this procedural jurisprudence that reveals court access obstructionism inconsistent with the rulemaker's priorities and lawmakers' commitments to substantive rights. So why should we care? Why should we care about stricter statute of limitations, higher pleadings bar, more rigorous class certification criteria, employment conditioned on waiving court access in favor of arbitration? Because the federal rules of civil procedure are meant to protect certain values. The values that are coveted include things like efficiency, uniformity, accuracy, predictability. But there are other values that are at stake. And I want to name talk about three of those values. One is court access. The rules were designed to make it easier to get access to the courts. The rules were merely the vehicle through which important policies were enforced. So process yielded to substance. Gamesmanship was not to bar ordinary people from seeking justice. Another value, resolution on the merits. The rules favor justice. The rule makers preferred enforcing rule of law over parties just winning over a technicality. And then finally, another value is leveling the playing field. The rules help put people with unequal power and wealth on more equal footing. Procedure helps redistribute power and reinforces equality among the parties. So the rules really play a democratizing function, as recognized by a number of scholars such as Owen Fiss, Erwin Chemerinsky, Judith Resnick, and Alex Reiner. So in addition to the values that are behind process, why else would we care? There is no dearth of major pressing issues to address. I've mentioned some: racialized police brutality, sexual violence, inhumane immigration policies, voter suppression, gun violence, mass incarceration, crushing poverty and wealth disparities, not to mention global warming. So prioritizing civil litigation procedure is admittedly difficult until one considers the futility of substantive rights without procedural protections. So when assessing whether it's the right time for corrective legislation, there will rarely be a time when civil procedure seems most pressing. But substantive claims never see the light of day or get robust enforcement without meaningful process. So given today's tumultuous political landscape and turbulent times, this is precisely the time to ensure that the civil justice system, at a minimum, functions to enable civil rights law enforcement. A new Civil Rights Act to reform civil litigation procedure in and of itself is critical. Now, although meaningful in its own right, it's admittedly only a part of a larger needed enterprise, but it's not a zero-sum game. Procedure and substantive law must develop synchronously. So this rigid dichotomy between them is false. To be sure, what ultimately may be called for is a more comprehensive and transformative piece of substantive legislation that includes criminal justice reform, voting rights reclamation, LGBTQ protections, among other things. But none of these frontiers can be traversed without the bland, tedious, hard work of procedural reclamation and reformation. So my work challenges lawmakers to take that modest but imperative step towards real access to justice. However, the court's obstructionism has been neither absolute or uniform, making it hard to address. It is death by 1,000 cuts. So this is the insidious power of incrementalism. Now, the extent to which there is a court access problem and its gravity has been the subject of significant debate. I contend that the court has reached a tipping point, the apex of the pendulum, if you will, where the status quo is no longer acceptable. So when viewed from a wide-angle lens, and we can step back 75 years to when the rules were enacted, or maybe the last 25 when this has been more acute, a pattern emerges of a greater number and higher barriers that are erected for court entry and merits-based decisions for those who are alleging civil rights violations. Now, I'll briefly describe how those procedures function, as Professor Arthur Miller likes to say, as stop signs to civil rights claims. All right, so as an initial matter, it's harder to enter the federal court system because of the Supreme Court's interpretation of Rule 8, pleading requirement under Twombly and Iqbal. We know the Supreme Court now requires plaintiffs to put forward facts, showing their claims are not just possible, but plausible. So plausibility is problematic for three reasons. One, empirical data shows not only are defendants more likely to file 12b6 motions, but civil rights and employment discrimination cases are more likely to be dismissed. Two, judges are instructed to determine what's plausible by relying on their judicial experience and common sense, an overly subjective standard which really allows personal perceptions to be outcome determinative. And three, because of informational asymmetry that often exists between the parties, it's more difficult for plaintiffs pre-discovery to show intentional discrimination as a plausible theory. So an example of that informational asymmetry is Lily Ledbetter, an employee at the Goodyear Tire Company. Here's how she found out about pay disparity at her job and what it was like for her to learn about hidden gender discrimination after almost 2 decades of working at the plant.
I went into work, as I always did, an hour to an hour and a half early, and to get my mail, to check my email. I looked at the mail and immediately fell out a rough, torn piece of paper, about a quarter of a sheet of 8.5 by 11 paper, 4 first names, Lily, and 3 men. And when I looked and saw how much those men were making, base pay only, just base pay, I just felt so degraded. I don't think I've ever had a lower point. Immediately, my mind started calculating overtime, because overtime was a big, it was a big motivator. I had children in college. We had a mortgage to pay. We had car payments. We had the usual expense that families have, and it was so hard to make ends meet. But then to stand there and look at those numbers and just think back how hard it'd been on my family when it was totally unnecessary. And I did not see how I could muster up enough of dignity to get through a 12-hour shift. I finally walked around a while and went into the ladies' lounge and tried to talk to myself and get my courage up, knowing I had to get through the shift. I really wanted to take my bag and go home. I really just wanted to run away and hide. But I couldn't do that. I couldn't. And I had to stay and face it. I got home the next morning. I explained to my husband what I had learned. And I said, unless you object, I want to file a charge with the Equal Employment Commission in Birmingham, Alabama. If I started it, I would be in it for the long haul. I wouldn't be a quitter. And he said, what time do you want to leave?
Another example of disproportionate hardship for claimants challenging discrimination is the restrictive application and interpretation of Rule 23, the modern class action rule. Far from being simply an intricate joinder device, this aggregation method is designed to empower everyday people to enforce public policy. Class actions were central to the 1960s civil rights movement as a vehicle for structural reform in cases involving school desegregation, prisoners' rights, employment discrimination. One of the most significant, important Supreme Court cases of the 20th century, Brown versus Board of Education, in fact, was a consolidation of 5 class actions. The drafters of Rule 23 in 1966 made it clear that the modern class action rule was designed with civil rights cases in mind, at least the B2 provision. So through class actions and statutory delegation of private attorney general status to ordinary people, private individuals and their lawyers supplemented, subsidized, and even substituted official government regulation. Federal courts applied a liberal approach to class certification in the civil rights arena. However, class action jurisprudence has become increasingly obstructionist. Although a rigorous analysis at the class certification stage is justified to make sure that the defendant receives due process, in the case of Walmart v. Dukes, the Supreme Court demanded that lead plaintiff Betty Dukes produce significant proof of a general policy of discrimination as a precursor to meeting the class certification requirement of commonality. raising the procedural bar even higher for victims of discrimination. So the court's heightened commonality standard, like the pleadings one, threatens court access and formal resolution on the merits, but on an even grander scale. The denial of class certification, especially in cases involving small claims, poor claimants, and vulnerable workers, can mean the denial of relief altogether and the under-enforcement of anti-discrimination statutes. But you don't have to take my word for it. Let's listen to Betty Dukes herself, who started at Walmart as a greeter and ended up the lead plaintiff and my client in the biggest employment discrimination class action in US history, where she sought to represent 1.5 million working women against Walmart for pay discrimination.
Our first witness this morning will be Betty Dukes. As many of us know, she's the lead plaintiff in the class action case alleging discrimination pay promotions, Dukes versus Walmart. When the company opened a store in her hometown, Pittsburgh, California, Ms. Dukes anticipated many opportunities on the horizon. She was hired by Walmart in '94. She's very happy about working for the company. She'd learned about the Walton family and their vast business empire in a community college class in the mid-'80s. As a student at Los Medanos Community College, she was placed on the dean's list. Obviously made Dukes and her family quite proud. When Walmart hired her, she had nearly 25 years of retail experience, including work as a head cashier and then as a department manager. This May 25th marked her 17th year working at the Pittsburgh Walmart store. She still feels positive about her work environment, believes in the strength of her case. She wants to go to trial and have her voice heard. I was struck by, somebody told me it was your favorite quote, which I think you may hear me using later on. It's, don't let fear get under your feet, for it will carry you where you don't want to go. That is a great quote. So over to you, Ms. Dukes. We'll put your full statement in the record, of course, but please go ahead.
Good morning to the chairman and members of the committee. I am Betty Dukes. I am honored to have been invited to speak to you this morning. The Supreme Court's ruling in the Walmart versus Dukes has brought me before this committee today. I would like to share a little of my history as a Walmart employee. I grew up in the city of Pittsburgh, California, and have worked at the Walmart store there for 17 years. I had worked in the retail industry for nearly 25 years before coming to Walmart. Most of my working career has been in the retail business. From the start of my career with Walmart, I sought opportunities for advancement. But during my 17 years at Walmart, I have received only one promotion. While working at Walmart, I received numerous awards for outstanding customer service and other duties performed well. Prior to filing this lawsuit in 2001, there was never any posting for management positions in my store. For the first 9 years that I worked at Walmart, I never saw nor heard of any system for applying to get into management. After the lawsuit was filed, I learned that my experience was typical of what other women had experienced at other Walmart stores. Once this lawsuit began, I also learned through Walmart workforce database that women were paid less than men for doing the same work in Walmart stores. Rather than bring a claim just on my behalf, I brought this lawsuit on behalf of the women who worked at Walmart stores in this country. We have evidence that countless numbers of us have been subject to the same working condition and the same practice which favored men. I had hoped this suit would permit us to get an order from the court to stop Walmart from treating women unfairly compared to men. I was disappointed last week when the Supreme Court blocked us from bringing these claims together in one single case. We have collected a lot of evidence that women consistently receive unequal pay and unequal promotion, supporting our efforts to try their claims together. Unfortunately, the Supreme Court, in a sharply divided decision, did not allow this case to go forward. Women will now have to pursue smaller class cases or individual action. We will continue to proceed on behalf of many women as possible who are part of the class. But many women will give up because it is too hard to sue Walmart on their own. It is not easy to take on your own employer. It is even more difficult when that employer is the biggest company in the world. In this country, there are many Betty Dukes who want their voices to be heard when they are denied equal pay and equal promotion. For many of these women, I am afraid that the court's ruling will leave them without having their due date in court.
Thank you very much. Both my time in the Senate and previous career as a prosecutor, I always felt people who did the wrongdoing should be held responsible. Ms. Dukes, we can speak about the legal theory of these things, but you're the person who's actually involved. Can you tell us what united you and other women employees at Walmart? I mean, how did you come together? What was it that happened? Because I think about what Justice Ginsburg referred to Justice Scalia's opinion. She said it's attention on what its focus, its attention on what distinguishes individual class members rather than what unites them. What were the things that united you?
An opportunity to have our voice and our complaint addressed. As you know, Walmart is a vast corporation. There are many Walmarts, but we are virtually spread apart. It's not that we can come together socially. We come together under this premises that we work in an environment that is very unfair in the treatment of its employees. We have many complaints, but this is just two that has come forth. We are trying to unite without having to be under the intimidation of losing your job just because you speak out. We are in a very intimidating environment. So this avenue was one that would have allowed us, without the fear of retribution, is to come forth and have our complaint addressed.
Are you going to give up now?
Absolutely not. The best is yet to come.
Thank you.
So my hope is that Betty Dukes is right. Unfortunately, Walmart runs counter to the values that we discussed underlying the rules. Walmart hands some of the most powerful and wealthy defendants another tool for dismantling group action and diminishing the power of low-wage workers. But plaintiffs that are actually permitted to seek class certification are the fortunate ones. Arbitration agreements that compel employees to forego class actions, along with other procedural protections, are increasingly found in employment and other contracts and are enforced by the courts. The Supreme Court's endorsement of arbitration over the last several decades has encouraged employers to condition employment on an individual's foregoing court access and foregoing class actions. Thus, employers who are not able to litigate their way out of class actions may contract their way out instead. And if class actions are the only realistic way that the law will be enforced, employers have effectively contracted for immunity. As Professor Miriam Gillis reminds us, aggregating claims has been particularly critical for low-income groups who can't afford individual litigation or are disproportionately harmed by abusive business practices and need the type of forward-looking injunctive relief that class actions offer. With approximately 40 million Americans living below the poverty line and another 93 million living close to it, there are a lot of people who will suffer because of the court's obstructionist procedural rulings. Finally, a claimant may not be able to bring a civil rights case in any form if the court determines that the statute of limitations has run, and if it interprets the statute of limitations in a way that is unjustifiably cramped. And this is what happened in the case of Lily Ledbetter, who you've already actually heard from. I'll let Justice Ginsburg share this quandary in her renowned dissent.
Justice Alito announced 4 members of this court, Justices Stevens, Souter, Breyer, and I, dissent from today's decision. In our view, the court does not comprehend or is indifferent to the insidious way in which women can be victims of pay discrimination. Today's decision counsels sue early on when it is uncertain whether discrimination accounts for the pay disparity you are beginning to experience. Indeed, initially you may not know that men are receiving more for substantially similar work. Of course, you are likely to lose such a less than fully baked case. If you sue only when the pay disparity becomes steady and large enough to enable you to mount a winnable case, you will be cut off at the court's threshold for suing too late. That situation cannot be what Congress intended when in Title VII it outlawed discrimination on the basis of race, color, religion, sex, or national origin in our nation's workplaces. Lily Ledbetter, the plaintiff in this case, was engaged as an area manager at a Goodrich tire and rubber plant in Alabama in 1979. Her starting salary was in line with the salaries of men performing similar work, but over time her pay slipped in comparison to the pay of male employees with equal or less seniority. By the end of 1997, Ledbetter was the only woman left working as an area manager, and the pay discrepancy between Ledbetter and her 15 male counterparts was stark. Ledbetter's pay was 15 to 40% less than every other area manager. Ledbetter complained to the Equal Employment Opportunity Commission in March 1998. She charged that in violation of Title VII, Goodyear paid her a discriminatorily low salary because of her sex. The charge was eventually brought to court and tried to a jury. The jury found it more likely than not that Goodyear paid Ledbetter an unequal salary because of her sex. The court today nullifies that verdict, holding that Ledbetter's claim is time-barred. Title VII provides that a charge of discrimination shall be filed within 180 days after the alleged unlawful employment practice occurred. Ledbetter charged and proved at trial that the paychecks she received within the 180-day filing period were substantially lower than the paychecks received by men doing the same work. Further, she introduced substantial evidence showing that discrimination accounted for the pay differential. Indeed, that discrimination against women as supervisors was pervasive at Goodyear's plant. That evidence was unavailing, the court holds, because it was incumbent on Ledbetter to file charges of discrimination year by year, each time Goodrich failed to increase her salary commensurate with the salaries of her male peers. Any annual pay decision not contested promptly within 180 days, the court affirms, becomes grandfathered beyond the province of Title VII ever to repair. Title VII was meant to govern real-world employment practices, and that world is what the court ignores today. Pay disparities often occur, as they did in Ledbetter's case, in small increments. Only over time is there strong cause to suspect that discrimination is at work. Comparative pay information is not routinely communicated to employees. Instead, it is often hidden from the employee's view. Small initial discrepancies, even if the employee knows they exist, may not be seen as grounds for a federal case. An employee like Ledbetter, trying to succeed in a male-dominated workplace in a job filled only by men before she was hired, understandably may be anxious to avoid making waves. Pay discrimination that recurs and swells in impact is significantly different from discrete adverse actions promptly communicated and easy to identify as discriminatory. Events in that category include firing, denial of a promotion, or refusal to hire. In contrast to those unambiguous actions, until a pay disparity becomes apparent and sizable, an employee is unlikely to comprehend her plight and therefore to complain about it. Ledbetter's initial readiness to give her employer the benefit of the doubt should not preclude her from later seeking redress for the continuing payment to her of a salary depressed because of her sex. Yet, as the Court reads Title VII, each and every pay decision Ledbetter did not promptly challenge wiped the slate clean. Never mind the cumulative effect of a series of decisions that together set her pay well below that of every male area manager. Knowingly carrying past pay discrimination forward must be treated as lawful. Ledbetter may not be compensated under Title VII for the lower pay she was in fact receiving when she complained to the EEOC. Notably, the same denial of relief would occur had Ledbetter encountered pay discrimination based on race, religion, age, national origin, or disability. This is not the first time this Court has ordered a cramped interpretation of Title VII, incompatible with the statute's broad remedial purpose. In 1991, Congress passed a Civil Rights Act that effectively overruled several of this Court's similarly restrictive decisions, including one on which the Court relies today. Today, the ball again lies in Congress's court, as in 1991 the legislature has cause to note and to correct this Court's parsimonious reading of Title VII.
So I agree with Justice Ginsburg. The ball is in Congress's court. We have come to a similar moment in time. It is time for Congress to draft curative legislation to rein in the restrictive ethos that permeates modern judicial rule interpretation and application. Meaningful access to and use of the civil court system has regressed to the point of requiring legislative resuscitation for constitutional and civil rights claims. Congress must step into the breach. Congress can tailor procedure to civil rights claims in particular, bringing the pendulum back to where such claims can be heard, decided on the merits, and systemically enforced. Now, this prescription is not abnormal. The court and Congress regularly volley over the meaning and interpretation of law. Such course corrections can be done on a broad scale, as evidenced by the Civil Rights Act of 1991, or surgically, as evidenced by the Lilly Ledbetter Fair Pay Act. To be sure, the legislative process is not a panacea. The process from bill to law is multi-layered and far more complex than Schoolhouse Rock would suggest. The process may also be subject to capture by powerful and wealthy interests who can exert undue influence on the outcome. But corrective legislation plays an important regulatory function, reining in jurisprudence that is veered too far from the original intent of the rulemakers and the lawmakers. So, why is another law the answer? If the court's interpretive lens skews in an obstructionist direction, what's to stop the court from interpreting a new law the same way, right? Why is law the answer? So a couple of ideas. Corrective legislation can offer unambiguous text that a textualist cannot refuse. A law can at least facially address the problem by making explicit in its text substance-specific procedure, something rules can't do because of the transsubstantivity of the federal rules of civil procedure. A law is appropriate also because of its coercive power to create broad, uniform, predictable, and fair outcomes. And then finally, a law is needed to promote societal values. A law would signal and reaffirm the country's commitment to, or at least aspiration toward, values of equality, justice, and democracy. Law plays a vital role in allocating power and signaling who and what matters in society. So it is time for the law to reflect and embrace that the experiences of marginalized people matter, and that the public adjudication system is there for them. Now, the creation of a new Civil Rights Act, to be sure, this would not be easy. Creation of this law involves interaction of a variety of stakeholders, judges, lawyers, politicians, social movement actors, media figures. Professor Lonnie Guinier refers to that collaborative enterprise of lawmaking between elites and ordinary people as jurisprudence. So this complex contextual interaction accounts for why and when restorative statutes arise. Now, there are a number of conditions that catalyze corrective civil rights legislation. And in this case, admittedly, the underlying conditions for restorative legislation are complex and wildly in flux. But I'd like to take a look at some of them. One is the quantity and quality of the Supreme Court's regressive cases. While the Civil Rights Act of 1991 overturned 8 cases, the Lilly Ledbetter Fair Pay Act only overturned 1, but it was a particularly salient case. So here, I think the number of cases and the gravity of those cases, certainly over the last half century or quarter century, justifies a legislative correction. It's the cumulative effect of incremental obstructionism that ultimately gets us there and justifies a new Civil Rights Act. Another condition or catalyst we might look at is the presence of a strong dissent. Here we have dissent, Justice Stevens in the Twombly case regarding pleadings, and Justice Kagan in Italian colors when it comes to arbitration and class actions. In fact, Justice Kagan admonishes the court for what she calls the betrayal of federal statutes. And she goes on to criticize the court for enabling arbitration to, quote, choke off a plaintiff's ability to enforce congressionally created rights, unquote. So these dissents, while not the clarion call that Justice Ginsburg had in her dissent in Ledbetter, do signal that it's time for a change. And then finally, I would venture to say, we look at one of the conditions or catalysts, maybe the most important, is this notion of party politics and degree of partisanship. So if someone were to ask, is it time for a new Civil Rights Act? I think the initial response would be no. Be careful what you wish for. Many legislators would be disinclined to disturb the status quo and in fact support the court's efforts to block access to the litigation system, one that is perceived as being beleaguered by crowded dockets, expensive and time-consuming discovery, and alleged meritless claims. When Congress has enacted procedural statutes, they've made access harder for plaintiffs. And finally, we're in this hyper-partisanship type of period, extremely polarized political climate today. So many people would say, we can't get anything passed because of congressional gridlock. Now, I want us to think if there may be some room for optimism. Could we get a federal new civil rights law passed related to procedure? Well, if legislators start now, it may take a few attempts. The Civil Rights Act of 1991 was initially vetoed and later signed into law by George W. Bush. The Lilly Ledbetter Fair Pay Act was initially rejected by a Republican Senate and then later passed as the first law that was passed under the Obama administration. And in fact, there has been some successful legislation regarding prohibition of pre-dispute mandatory arbitration agreements as it pertains to certain types of groups. So for example, members of the armed forces who are subjected to payday loans have gotten that protection. Federal employees with sexual assault or harassment claims against federal defense contractors have gotten those kinds of protections. The political landscape is also a dynamic one. The composition of the House is more diverse than ever before. When it's one of the youngest geographically diverse Congresses, more women, more people of color, more veterans than any other Congress. So there's a greater diversity of perspectives. And despite significant gridlock, there has been some legislation that has been passed. We've seen the reauthorization of the Violence Against Women Act, the reauthorization of the September 11th Victim Compensation Fund, and some legislation related to coronavirus relief. So the hope is that this gridlock will not go on indefinitely, and that we don't respond to this gridlock with moral resignation. I think one of the most salient developments that may catalyze corrective civil rights legislation is the Black Lives Matter racial justice movement. Activists and their allies are hungry for change and are challenging injustice and systemic racism in all its forms. So grassroots demand for serious change suggests that the time is right for stronger civil rights enforcement. Despite the common narrative, court access is more about people than partisanship. Procedural injustice disproportionately impacts the poor and powerless of all political stripes. Veterans challenging untenable delays in medical benefits, women challenging sexual harassment on the job, African Americans challenging police violence, and low-income people challenging draconian payday lending terms all benefit from a civil court system geared towards providing them with their proverbial day in court. Enhancing court access promotes rule of law, democracy, and justice for all people. So now more than ever, it's important to be able to access the court system and fight for enforcement of our civil rights laws. I will close with a quote from the Reverend Martin Luther King Jr. in his letter from Birmingham jail in August of 1963 on why it is time for this new Civil Rights Act.
For years now I have heard the word wait. It rings in the ear of every Negro with piercing familiarity. This wait has almost always meant never. We must come to see with one of our distinguished jurists that justice too long delayed is justice denied. We have waited for more than 340 years for our constitutional and God-given rights.
Thank you. I'd now like to open this up to Q&A and invite the Dean to return.
Thanks. Thank you, Suzette, for a very enlightening presentation. It's clear you've made a compelling case about the limitations that have been put in place by the Supreme Court incrementally over the years and how that has affected people in real life situations to disadvantage them. I'm wondering if you could reflect a little bit about why the court has moved in that direction. What is the motivation? What are the forces behind the direction that the court has gone over the years? Obviously, a majority of the court or majorities of the court have thought they were right in those decisions. I mean, we've heard the counter argument. They're very well presented today. But for those of us who are either curious or might be thinking, well, there must be some valid reason why the court has gone this direction incrementally over time. What would you say in that regard?
Yeah, thank you, Jim. First of all, I would say that the court is not uniform, right? And so a lot of the decisions that I have referred to are very close, 5-4 decisions. So highly contentious with, strong dissent or, moving in a different direction. That's particularly true when it comes to the enforcement of our arbitration agreements. We've seen some pretty strong pushback. And so the court is definitely not acting uniformly. I am not, obviously not in a position to know what's in the heads of the justices, but there's been an ongoing debate about to what extent our court system is out of control, right? Is it true? And there are a lot of scholars who've done some empirical work on this. Is it true that discovery has run amok, right? And I think that's a narrative that it's very expensive and that it's time consuming and is sort of taken over. That is a narrative that has, in my opinion, been overblown and isn't supported by empirical evidence. But there is definitely that narrative out there. There's a sense of, and I think this is true, that the lower court judges are probably overwhelmed with dockets. And so we have shortages in terms of judgeships that need to be filled, or the needing to think a little bit creatively about how that labor is distributed. And so I think judges are looking in some ways for how to resolve issues short of litigation. So this move towards arbitration is part of that. I think that's part of that response. And there's certainly an impression, there is an impression among some that really what's going on is the corporate interest, that powerful interest, that corporate interests are being favored, right? If we look at what are the underlying values behind the federal rules of civil procedure, efficiency is one of them. There are, looking to see what do we lose, right? What do we lose by actually not allowing some of those cases to come in? So people who are using the court system to challenge power, right, and to seek civil rights and justice are really kind of pushing against the grain. And to what extent is the court system there for them versus those who have more power? And so the more powerful, I think the cases are leaning in their direction. We have to also consider just the diversity of the court itself, that, in terms of diversifying the court. And so making sure that it is not a place that replicates elitism, replicates power, but it in fact is more, more aligned to the entire spectrum of people in the country, I think is important. But it's a good question. I mean, I think that there are some legitimate concerns about the civil litigation system and how it's working, but I don't necessarily think that the court as an institution is the right institution to answer the question. I think there are some that have better expertise, like the rulemakers for one. So I think it is a mistake for adjudication, for rulemaking or process making to happen through adjudication by the Supreme Court, which is not nearly as equipped to do an analysis as the rulemakers can do when they're putting together the rules. So there's some institutional, I think, problem there.
A lot of complex dimensions, and the composition of the court. That's
well,
discussion.
Yeah.
We have several questions, and unfortunately our time is limited, but let's try to get to at least a few of them.
Sure. Great.
Professor Ming Chen, sort of the goose for the gander type question. First, she thanks for the insightful and engaging talk, but if she says that she asks if procedural rights are value laden, i.e. not neutral, can they then be equally used for progressive and regressive ends? For example, national injunctions have been used to defend against restrictive immigration policies, e.g. Muslim travel ban, and also to advance offensive as a sword, so to speak. Texas, for example, Texas versus the U.S. lawsuit challenging DAPA.
Yeah, so I'm understanding the question to be whether certain certain rules of procedure are actually going to favor one side more than the other. Yes, I think that's true, and it may not be. If we look at the rules on their face, I mean, they seem neutral, and so I think that's one of the things that can throw people off, is that they are kind of shrouded in language that doesn't seem to have any impact, but they have a disparate impact on certain types of claims. There are certain rules that have those claims in mind. So I will say Rule 23b2 The modern class action rule, that provision actually was designed with civil rights in mind, right? To make it so that it is easier to seek injunctive relief on behalf of a group. And the rule makers, this was in 1966, they were very aware of all of the legislation around them. And so that is an example. There are not many of them, but it's an example of where the rule makers, in fact, were encouraged by sort of particular types of claims. I think what happens more often than not is that the rules look neutral on their face. They have a disproportionate negative impact on certain types of claims. And there's a whole, in the background, there's a whole there's movement behind how these rules get promulgated, right? As you know, it takes maybe 2 to 3 years before a rule change can come down. And the court, the judicial conference and others will go around the country and collect information from different stakeholders on what they think about those rules. You've got judges, lawyers, academics, all kinds of folks who are weighing in to the public comment process. So thousands of people are weighing in when it comes to the rule making process. The language of the rules can seem very subtle, but there are political dimensions to what happens. And so I'll give an example. The discovery rule, recently discovery has been changed. And so the notion of proportional discovery, proportionality has been imported in the definition of the scope of discovery. Now, who would think that that means anything? Why would that be important? But there are a lot of people who fought very hard over that because it does mean something. It's not necessarily obvious, but it means that it's another barrier. It's something that makes it more difficult for somebody who's bringing a case. They're going to have to justify the discovery that they ask for. And that's yet another that's another obstacle. And so many of the rules, while neutral, in fact, have a disparate impact. And that's not necessarily obvious.
Right. Yeah.
I hope that was helpful.
Sorry, I'm losing my place here. A lot of great questions coming up. Catherine Powell says, brilliant lecture, fantastic use of video clips. I have a very great question here by Ashley Boothby. Says, I was wondering if you might be able to address the hollow hope, quote, hollow hope argument about how social movements can sometimes be weakened by these kinds of legal strategies. The idea that somehow we put so much weight in the law and its capacity for change when problems are more deeply seated.
Yeah, that's fair enough. I think that I don't mean to suggest, I know I'm, rah-rah on the law here, but I don't mean to suggest that the law is a panacea, that it is going to solve everything. Quite the contrary. I think the law is part of is a piece of a very complicated puzzle. And you can, the law has clear limitations and you can only get but so far. Recognize the Civil Rights Act of 1991, the Lilly Ledbetter Fair Pay Act, all of these corrective legislations, they're also compromises and pretty serious ones. So I'm sort of not under the illusion that the law is going to solve everything. Especially if you're talking about a court that is, is committed to a certain interpretation, the law will get you but so far. I'll just give you one small example, but I worked on a case where we represented the victims of the Tulsa race riot of 1921, which many of you probably know. There was the Black Wall Street, right, in 1921, that was completely decimated by a white mob, deputized by the government of Tulsa, killed thousands of people, destroyed the entire community. And we tried to, the lawyers in the case, we tried to represent our clients who are 90-something, 100 years old, right, the victims of that riot or that massacre, really. And we did not succeed in terms of the legal strategy, right? We were killed on the statute of limitations. That happened in 1921. There was a 2-year statute of limitations. Obviously, no court was in a position, no African-American was in a position of getting justice at the time. And so we brought the case when we had sufficient evidence, right? There was a whole commission and report that was done on this, and we finally brought a case seeking to represent our clients. And the court, we could not overcome the statute of limitations problem, right? And so because that was not successful, we tried to take it all the way up to the Supremes. We had to take it outside. We had to take it and look at the international. Could we get relief through the international courts? Could we get relief through legislation? Ultimately, none of those vehicles worked. And so we ended up, people did documentaries on it. And we had to know that the best thing that we could do through that litigation was just educating people about what happened in 1921 and also making sure that our clients felt heard, right? After so many years and decades of being ignored, that they felt that the system was there for them. But it's just an example where the law is not everything. By no means.
Yeah, and that's a very important point about the educational value of itself and the effort and the multifaceted nature of it. We're almost out of time. Well, we are out of time, but just one more question.
Sure.
And if you don't mind, Suzette, that regarding in connection with this multifaceted, this notion of multifaceted effort, we have a question from Rachel Ellis who says Colorado's Civil Rights Act, now CADA, preceded Title VII by more than a decade. And we currently have some strong momentum here. Do you think that focusing our efforts on state legislation is a good way to use our energy?
I do. I think that's a great question. And I think it's an important vehicle to think about because the Colorado Civil Rights Act is more generous. And, as people probably know, more recently, we had legislation that when it comes to police accountability, not allowing a qualified immunity defense for violating the Civil Rights Act as it pertains to police misconduct. And so that is more generous than what is available on the federal level, right? Where you bump into this qualified immunity defense, which really can kind of sort of shut everything down. And so I think focusing on the state and the generosity of some of the state constitutions is something that we're going to see more of. And it's certainly something we should see in Colorado, because I do think, relatively speaking, we are stronger and we are ahead of that curve when it comes to the civil rights issues.
Right. Thanks. Yeah, we have several more questions, really attesting to how engaging the subject is, and your presentation has been, Professor Malveaux, but unfortunately we're out of time. So we'll have to end here. Thank you all for joining us this evening, and I'd like to once again thank Professor Malveaux for a terrific lecture and for all of you for a great discussion.
Thank you, everybody. I appreciate your feedback and your questions.
Yeah,
I look forward to continuing that conversation.
Great. And thanks again for our terrific staff and, of course, our wonderful IT team. Have a great evening, everybody. Take care.
All right. Thank you, everyone.